As the Twin Cities area reels from the latest killing of a black resident by a police officer, the murder trial of ex-Minneapolis officer Derek Chauvin resumed on today, right? Now, cardiology expert Jonathan Rich testified that George Floyd showed no signs of heart problems and that he did not die from a drug overdose. We also heard emotional memories from George Floyd's younger brother and damaging testimony from a police use of force expert who said no reasonable officer would have done that, what Chauvin did. Chauvin is charged with second-degree unintentional murder, third-degree murder, and second-degree manslaughter in Floyd's death.
Joining us right now to discuss today's proceedings, as always, civil rights attorney Sue Ann Robinson. Sue Ann, thank you so much for being back with us today. I know you are now in Minneapolis. I know you've had a pretty emotional night and day with, everything happening. We just touched on the shooting that happened in Brooklyn Center, and now we're going to talk about Derek Chauvin's trial. You were with the family today in Minneapolis watching this trial. Can you tell us a little bit about their emotions, what they're dealing with? I imagine even last night's information has been upsetting.
Yeah, absolutely. I mean, the emotions and the vibe is, wanting this to be over and wanting justice for George Floyd. So, we're watching and just evaluating and hoping for the best. Today, PJ was the star of the day. He was carrying the family, all their well wishes before he went into court. Everyone said a prayer for him and sent him positive thoughts because the anticipation was that he was going to be cross-examined about his brother. And obviously the emotional state of losing his brother and also losing his mom within a short period of time, it can weigh on you and it can affect you while you're trying to give testimony. But he did an amazing job. And he did such an amazing job, in my opinion, that the cross was waived by the defense.
Yeah, that is true. We saw what happened with Dante Wright in the same area pretty much. But that's going to lead to my next question. Do you think the judge refused the defense's request to sequester jury this morning? Was it because they were maybe trying to do something different with the jury because of that incident?
No, I think the judge is 100% spot on. You don't want to make the jury draw their attention more to another incident. So because this issue occurred and it deals with police misconduct, police excessive force, a police shooting, and to say, oh, now we should sequester the jury because there's another case occurring, I don't think that's the right call. I think the defense was just trying to do something, and that's kind of been his theme for these past few days, is let me just throw something against the wall and see what sticks. The jury's going to be sequestered while they think about the case during their deliberations. There's no reason to sequester them now. It would only raise their awareness and make them look around and say, well, what is going on? Why are we being sequestered? So Chauvin isn't involved in it, and it's a different police department. That case will be dealt with how it's dealt with. It's not like, and as Judge Cahill said, it's not like a situation where another verdict in another case came in and there's issues with it. The defense attorney was trying to argue that, the jury's safety could be at risk because of this new case. It just, it fell flat for me and for the judge.
Something else, and Sue Ann, the judge denied one of Floyd's family members entry into the courtroom today, and I'm hearing, that had something to do with the jury as well. Can you break that situation down? What happened?
Oh, well, one of George Floyd's brothers wanted to go in the courtroom today because the family has a seat every day that they can enter the courtroom. And he wasn't permitted to stay in the courtroom because he had on custom Air Force Ones that say Justice for George Floyd and Black Lives Matter. And apparently the defense attorney argued that could cause an issue if the jury saw his shoes.
That is interesting.
It is.
That is very interesting. And thank you for that insight, because I actually didn't know why. So thank you for that special knowledge that you have there. We're so happy to have you. So today, law professor Seth Stoughton, he's a police use of force expert, testified. Let's take a look at that.
So you considered whether or not Mr. Floyd might have passed away from a primary heart event or a drug overdose. Did you reach an opinion or conclusion to a reasonable degree of medical certainty as to whether either of those two causes explain Mr. Floyd's death?
Yes, I did.
Would you tell us your opinion?
Sure. After reviewing all of the facts and evidence of the case, I can state with a high degree of medical certainty that George Floyd did not die from a primary cardiac event, and he did not die from a drug overdose.
Thank you, Dr. Rich.
So, Sue Ann, of course, we had Dr. Rich, we had Seth. I mean, lots of testimonies, compelling ones, and a lot of good knowledge was given to us today. Kind of give us your thoughts on what you saw, from your side of things for the during the Derek Chauvin trial today.
I think we were all happy with Dr. Rich's testimony because as a leading cardiologist in his field, him laying out and going directly against point for point the defense's theory that what happened to George Floyd had to do with the cardiac arrest or some sort of heart attack, I think he completely demolished that argument for the defense. And that was the point of calling him, so that he could talk piece by piece, little by little about the heart, educate the jury on the heart, what the different pieces are involved in cardiac arrest, and explain that what happened to George Floyd had everything to do with Derek Chauvin's actions and nothing to do with a spontaneous heart attack.
Yeah, I'm glad you mentioned that, Sue. And Dr. Johnson Rich went on to say Floyd's death was preventable. Let's take a look right now.
Opinion as to whether George Floyd would have lived if not for Mr. Chauvin's subdual and restraint of him for 9 minutes and 29 seconds on the ground.
Yeah.
Overruled. A reasonable degree of medical certainty.
Yes, I believe he would have lived.
Now, in this case, or shall I say, is this case still in reasonable doubt zone? What do you think?
No, I really don't. And after Seth testified, who literally wrote the book on police excessive force cases just last year, I think that the state is ending their case as strong as they started it. They've stacked their case with experts in every way. Seth was obviously the trifecta, a former law enforcement officer, a lawyer that's also a law professor, giving the jury through his testimony the instruction on how to interpret the reasonable officer standard. I think honestly, and I kept saying it today, that he was one of the most important witnesses in the case because his testimony goes directly to what the jury has to consider, which is whether or not what George Chauvin did caused the death, and Derek Chauvin did cause the death of George Floyd. And then, of course, whether or not his actions were reasonable. So I think him discussing that was very important and a great way to end today in the prosecution's case.
So today we also heard pretty quick but powerful testimony from Floyd's brother. Why do you think the defense decided not to cross-examine? You touched on this earlier and kind of touched on the fact that it was strong testimony, but break that down a little more for us.
I think that if the defense would have gotten up and tried to attack someone who is clearly in mourning for their brother, they would have lost any iota of credibility that they still have. I think PJ did an excellent job in kind of giving us that spark of life testimony, which is what the purpose of the state calling him as a witness was. He did a great job. He, leaned into his emotions and acted very naturally under the circumstances. He was relatable. He talked about his brother. You got a picture of who George Floyd was to his family, or Perry as they call him. And then you also even got a glimpse into his mother and their relationship to kind of give you an idea of this is the person who raised George Floyd, someone who the entire block, the entire neighborhood called mom. It just gives you that good feeling, positive feeling, because this, throughout the trial, obviously we're talking about George Floyd, but you don't get to really talk about him as a person. We just talked about him and discussed him as someone who was killed. So PJ did an amazing job today, giving that spark of life to his brother and, really representing for the family.
Sue Ann, thank you so much, because I actually agree with you. This is the first family member that we got a chance to see. And so I loved his testimony. But you keep saying a term called spark of life. And a lot of people are saying his testimony was a spark of life testimony. Can you explain to our soulmates who might not know, what does a spark of life testimony mean?
Sure. In Minnesota, in trial court, in a murder trial, you're allowed to enter into evidence what is called spark of life testimony, which literally is supposed to give the jury a spark into the person who was killed or allegedly killed. In our case, we know what happened, but into their life and who they were, so that you're not just talking about a dead person, you have an idea who they were in life.
I must say this, Sue Ann, it looks like tomorrow that they may be switching over to the defense. Now, if that is the case, explain to our soulmates how they can initially say, we want this to be thrown out of court, so to speak. What is the right terminology for that? But can they initially ask for that before they bring their defense to life?
Oh, yes. Okay. So after the prosecution rests, the defense will have an opportunity to make a motion for directed verdict. And a directed verdict basically it's a standard argument that the defense makes after the state rests its case. And it basically says the state didn't meet its burden under the elements of the case. But it's a standard motion. Okay. Every case, the defense attorney does it. This isn't a case where there's a lack of evidence or where, the state hasn't called any witnesses or something like that, where that would even be a real consideration, but it is a standard procedure.
Sue, and I actually have one question, and I'm glad you brought that up, Romeo. So with the defense starting to bring in their witnesses, do you know anyone that they're going to have come in? There was only one person that we've heard so far that we know for sure, but are you aware of anyone that's going to be coming in on the defense's side, just so we can kind of brace ourselves for what's to come?
The state literally was advised that Eric Nelson supposedly doesn't even know who he's going to call.
Really? Interesting.
Okay.
So I guess we're all going to see.
Yeah,
See you next
We're
week.
going to be watching. We're going to have you here
sure
breaking
will.
it down for us as well.
Well, thank you
All
so
right,
much.
guys.
We are so happy to have you yet again, and we will see you and talk to you tomorrow.
All right. Bye, soulmates.
Bye. Okay, great. So let's check in really quick with our YouTube soulmates. 1-4 Low says, we just need to get rid of the police entirely, protect ourselves and our neighborhoods. And that's something that Brooke talks about a lot. Sophia One says, well, she doesn't say get rid of the police. She doesn't say that, but we talk about different levels of policing. We'll get into that a little bit later in the show. Sophia One says, her taser is bright yellow. You didn't see the difference? Last one here, RJ Renee says, do y'all think the defense is doing an incompetent job in order to ensure Chauvin can appeal for a new trial? I mean, the commentary is just cooking up. Keep it rolling in, soulmates, and Romeo's going to let us know what's coming up next.